express my sincere appreciation to the esteemed members of the legal committee, our chairperson, Mr. T.N. Mitro, our committee members, Mr. Porito Shina and Mrs. Suchurita Basu, for their continued efforts in curating such meaningful sessions. We are truly honored to have with us today a distinguished legal expert, Mr. Sabyasachi Chaudhury, Senior Advocate, presently the Secretary, Bar Library Club, High Court, Calcutta. His experience and contribution to the legal field are widely respected. Mr. Chaudhury will share his insights on the evolving landscape of commercial arbitration and conciliation, and we are certain that his thoughts will give us a deeper and more practical understanding.
Prashanta sir, you are on mute. Thank you so much for the formal welcome address. So moving on, I would request our honorable speaker for the day to please enlighten us the subject, and we are eagerly waiting to hear from you, sir.
All right. Am I audible? Is the audio clear? All right. Well, thank you very much. Thank you for the introduction. And at the beginning, I express my gratitude to the entire team of Bengal Chamber of Commerce for having me in today's session. The topic which has been chosen is of a very wide amplitude. So there are three prime expressions. So one is the word commercial, one is the word arbitration, and lastly, we have the word conciliation. Now, so far as commercial part is concerned, that's more or less an adjective, because there is no separate law so far as commercial arbitration is concerned, or conciliation is concerned. The law for arbitration and conciliation is the same for all matters, commercial or non-commercial. But there are certain features of the Act which the legislatures perhaps thought would be useful in a commercial arbitration. But unfortunately, that feature has been put to little use or no use. I'll come to that later. But the difficulty of a lawyer speaking is that we tend to legalize things and speak legal jargon too much. And I assume that members of the Bengal Chamber of Commerce, there are many non-legal persons for whose benefit this session is being held. So to put it in very simple terms, commercial, just take it that it's an adjective which is qualifying the two words arbitration and conciliation. Now, what I briefly propose to do, because you see a talk on such topics tend to become very boring, in the sense that it's not a question of what I know, it's a question of putting it in simple terms to convey what you should know as laymen or as men of commerce or men or women of commerce. What are the aspects of arbitration and conciliation that you should know, so that it can be of help to you in your day-to-day transactions or in your day-to-day affairs. Now, that being the entire object of today's talk, let us first quickly, and to facilitate even a layman, of course, most of you here, or in fact all of you here, might be aware as to what an arbitration is and what a conciliation is. But assuming there may be one or two to whom this difference is not very clear, well, arbitration is nothing but an adjudication in a private forum. So just as disputes arise, and in business disputes are bound to arise, and normally go to court, instead of going to court, you go to your chosen forum, that is where you are comfortable. It's often referred to as a private forum. and you sort of ventilate your grievance, and there is adjudication. So just as a court adjudicates, an arbitrator or an arbitral tribunal is also supposed to adjudicate. So there is an adjudicatory mechanism which is in process. This is in broad parameters what arbitration is. Now, how do you select a private forum? You select a private forum by agreement. So if you are having a commercial transaction, you put in that sort of an agreement that, well, I'm entering into a contract with somebody else. I just put it in the agreement itself that if there is an issue between the two of us, we would prefer to go before Mr. X or before an institution. So who would look into the matters, and whatever that person or that institution would decide, we would abide by the terms. These are the broad contours. Now, as opposed to that, we have this third expression called conciliation. So exactly what we mean by conciliation, the word itself, like without going into legal jargon, there is a conciliatory approach in the word conciliation itself. So how do you effect conciliation? Well, there are many elements, not only in commercial transactions as well as non-commercial transactions, where parties feel that, very well, let us not waste our time and money in going to courts and arbitration, because good, bad, indifferent arbitration also in present times, and especially commercial arbitration, is very expensive. And it has become expensive, often boiling to the question of being illusory because of the prolonged period for which it goes on, the fee structures, the costs, and whatever it is. So what was initially a virtue has turned into a vice in many cases. We'll discuss that, or we'll throw some light on that later. So conciliation is sort of an approach where it's not like settlement, though it results in settlement, where both the parties, there is an element of agreement. That is, if both the parties do not agree, then you can't have a conciliation. So there has to be an offer to conciliate. It will be accepted by the other, and then you sort of, instead of the two warring parties, you choose again a third person who is called a conciliator, and he sort of sits with the two and tries to minimize the issues or sort of smoothen the edges and try to see that you can arrive at some broad terms of what is broadly called a settlement. And ultimately, if the parties are able to agree, then in conciliation, the result is a settlement agreement. Now, this is where the two paths which are completely different is again uniting, in the sense that in an arbitration, it's an adjudication. That is, whoever is the arbitrator is deciding which side is right and which side is wrong, and if the side which is right, what are the reliefs or what is he or she getting. There is an adjudicatory element, and the decision is called an award, and you enforce it like a decree. There are limited grounds of challenge, but you can otherwise enforce it. But then now, under the present, we'll discuss that. What are the lacunas in that so far as an award is concerned? Because in most cases, and even in commercial matters, unfortunately, though a successful party is armed with an award, the process of the courts and the law is such that because of the pendency of the challenge, which we called a Section 34 proceedings, the award often languishes in court. So what you tried to avoid indirectly has come and sought to haunt you directly. But we are now on conciliation. In case of conciliation, once you arrive at the settlement agreement signed by the conciliator and the parties, you can enforce it, or in law, you can enforce it just as an award. That is just like a decree. Now, the elements of conciliation, because it was sort of rooted in the agreement of the parties, that has been now modern concept. The terminology is mediation. they call it mediation, and mediation is something which is imposed, sort of imposed on you by law, in the sense that especially if you want to go to a court, that if your disputes are commercial in nature and you want to go to court without going to arbitration or conciliation, so you will have to attempt what is called a mediation. Now, mediation has elements of conciliation. It's like, to put it very simply, all conciliation has an element of mediation, but it's not the other way around. So you have institutions which are acting, or you have individuals who are acting as mediators, and you go there. It's sort of a give and take, and the word itself is quite clear. Now, having understood what are the parameters of what we call an arbitration and what we call a conciliation, let us delve slightly deeper. Now, why should businessmen or men of commerce prefer this methodology of arbitration or conciliation over courts? So this is a question which was asked decades ago, and the prompt answer would have been that, well, in courts proceedings go on and on and on, and therefore this is a more efficacious way of finding out a solution. That is, we know what is the scope of our contract, we know what is the scope of our ambit, and therefore we choose a private forum where we ventilate our grievance, and whoever is the adjudicator, whom we call the arbitrator or the arbitral tribunal, they hear both sides and they come with an adjudication that this side is right and that side is wrong, and so on and so forth, or partly right, partly wrong, whatever it is. Now, why should men of commerce prefer the arbitration route? Well, the answers are obvious. It is supposedly faster. It is confidential, which is one of the prime reasons that people avoid courts, that people at large or public at large are not supposed to know what grievances we are ventilating against one another, because we are all men or women in business, and there may be competitive issues, there may be rivalry issues, there may be other issues which requires a degree of confidentiality. And this is one of the essential features of arbitration, that whatever grievances you may have against the other party or your adversary, the entire proceedings are done in an element of confidentiality, in the sense that the public at large are not privy to what allegations and counter allegations you are levying against one another. So this is one of the first and foremost advantage of having an arbitration over the regular courts, because in a court proceeding, anybody and everybody can go and have access or can hear at least what is happening. The other aspect is that in arbitration, because the forum is private, you have what is called a flexibility of procedure. That is, you do not, or the law does not suppose that you have to borrow in the rigors of elaborate evidence and elaborate cross-examination and technical aspects of having solemn proceedings, taking oaths and all that. Elaboration is something which can be dispensed with. But having said that, as I said, that in the entire aspect of the law of arbitration and conciliation, what is supposedly a virtue is also a vice. That is, it's the two sides of the same coin. Now, most of the people who are involved in arbitration today are either lawyers or retired judges or men dealing in the field of law. And knowingly or unknowingly, we as lawyers and arbitrators, as retired judges or men well-versed in law, often get bogged down by nitty-gritties of technicalities which plagued the civil courts and the civil proceedings. So what was supposed to be efficacious, because of the majority of the people involved being persons who are regularly practicing in courts of law or having been adjudicators in courts of law, former adjudicators in courts of law, unknowingly or knowingly, we tend to borrow down, or we tend to bring in these procedural nitty-gritties, which somewhat affects the efficiency of the proceedings even in arbitration. So as men of commerce, you should keep in mind that it is very essential to understand that arbitration, it is supposed to be fast. It is supposed to be not bogged down by nitty-gritties of technicalities, but given the fact that our arbitrators and our lawyers and counsels with whom we frequently deal with are also the same people, or majority of them are the same, who does court proceedings, knowingly or unknowingly, the technicalities, they come in. Sort of, it's a baggage which they have inherited, and knowingly or unknowingly, they have put it in that. Now, notwithstanding this and this negative aspect of that, arbitration is still much faster than what a normal court procedure would have been. That is, if two parties, and let us talk specially of commercial disputes. If you are having a dispute, you can have a faster method. You can have a faster method of dispute resolution. Of course, we have the introduction of there is a procedure, a fast track procedure, which has been introduced even in civil suits. But then the resistance to that is having a adjudication only on summary proceedings, that is, the resistance is quite big, which is very difficult to overcome. But that's a topic of a separate discussion. Coming back to arbitration, when people in commerce, or men and women in commerce, they have a dispute, which is inevitable, you should prefer arbitration, notwithstanding its vices. But the reason why I mention these vices are that you should be aware of these vices, especially for you to choose your arbitral tribunal and also your counsels or advocates, whoever is representing your case. Now, why the role of the arbitrator or the person you are choosing becomes important? Firstly, because of his integrity. He should be a man or woman of impeccable repute. And also, the background from which the individual who is chosen as an arbitrator is coming from. Now, for people of commerce, if the adjudicating authority does not have a commercial background in the sense of having prior experience in the field in which the disputes are arising, it is bound to be delayed or prolonged because of nitty-gritties, either because he or she is a man or woman of law, or because of the ignorance of that person in commercial matters. So this becomes very important. Now, the obvious question is that at the contract formation stage, which is the vital stage, and that is why it brings me to the next point, or the vital point which I want to draw your attention, that your entire focus has to be on how you draft your arbitration clause. Because I find with my little experience that the arbitration clauses are usually a copy-paste job. It's sort of transposed or lifted lock, stock and barrel from some contract which has been entered into between two parties whom you feel that, all right, they are very big organizations. So if they have this arbitration clause, we can very well copy it and paste it. So that is not how it works. You can definitely customize yours, and this is where your commercial experience, your commercial foresight comes into play. But I would like to emphasize in this session a section in the Arbitration and Conciliation Act which is rarely put into service by the parties. And that is called Section 29B. Now, for the uninitiated, this is something of a fast-track procedure which was introduced in the law sometime in the year 2015. Now, the reasons why this section was introduced was that because, you see, we have a history of arbitration long back, even prior to independence, because even when the British left us and we got our independence, we still then had what was called the Arbitration Act of 1940, and that continued for nearly 40 to 50 years. And then in 96, we had this present act of ours, which is really a borrowed sort of legislation from what we call the ancestral laws. Now, having said that, this 29B is a fast-track procedure, and it is particularly of help to people dealing in commercial matters whose scope of dispute is very small, in the sense that it's either a simpliciter monetary dispute pertaining to accounts, and there are 3 or 4 documents which it's glanced you can easily arrive at and some sort of an adjudication. Secondly, in technical matters where you don't require much technical expertise, or you have certain established parameters from which you can easily ascertain who's in the right and who's in the wrong, you can have a fast-track procedure. That's called the fast-track procedure, or a procedure under 29B. And the special feature of this is that it has to be a sole arbitrator. You can't have a 3-member tribunal or a multi-member tribunal. It's a sole arbitrator, because law is assuming 2 things. Number one, the scope of arbitration is on a smaller scale, or the scope of dispute is on a smaller scale. That is not to say that the claim amount is low. It has nothing to do with the claim amount. For instance, let us say if you are talking of money lent and advanced and a financial transaction, the transaction amount, whether it is a small quantum of 2 or 3-digit figure, or it's a 10-digit figure, if it is a case of, ascertaining from check dishonor and simple accounts, you easily can incorporate what is known as the fast-track procedure, where what you do is the time limit is shortened to 6 months. That is normal arbitration. If the normal time limit is 1 year, then this is 6 months. And second, you choose the arbitrator. It is best to choose the arbitrator, and you choose the personnel of the arbitrator at the contract formation stage itself, because here the integrity of that person has to be impeccable, because he or she is wielding much more powers, because you are not having the luxury of long drawn litigation, in the sense pleadings, then evidence, then long drawn arguments, and then that. It's a simpliciter, short procedure where you just put in your written pleadings and written arguments, and only if the tribunal feels that, or the arbitrator feels, it's incorrect to use the word tribunal here, the arbitrator feels that you require an oral hearing, or the arbitrator requires some sort of a clarification, the arbitrator may call for 1 or 2 sittings and say, all right, you clarify. In other words, the documents are so clear that you don't require more than that. So if you can choose, and in this category, especially for people in commerce, if you have experts in your field of business, for instance, you have these institutions, arbitration institutions, which are specialized because of a particular, the disputes ranging in a particular field. For instance, shipping, you have a specialized institution doing shipping arbitrations. Why? Because they are all persons conversant with that. You have specialized institutions dealing with engineering disputes. Of course, now it is coming into vogue in India in a big way, but then we are still much behind the international world or the world at large. And it is now we are trying to portray India or make India into an arbitration hub. We are looking into that. But to come back to 29B, I have found that though this section is there in the statute book for over 10 years now, I have hardly come across the utilization of this section in matters of disputes pertaining to commerce or in commercial disputes, where it could have been effectively utilized. And again, I say that these are, or this provision can be effectively done in a matter where the scope or ambit of the dispute is on a much smaller scale than other matters, that it would not require expert evidence and technical issues and all that. It is simpliciter, an adjudication which can be done on a perusal of few documents or only documents. And this can be easily done away with. In fact, to be very honest, if you ask any lawyer who handles commercial litigation, 99% matters can be handled only on the basis of documents. It is only 1% matters where evidence or oral evidence or trial has somewhat impact. And that is very minuscule. It's only 1% or maybe less than that. But then again, as I said, that we knowingly or unknowingly, we have borrowed the trappings of court, which the arbitration process had tried to avoid. Now, this is so far as the fast track procedure is concerned. So when you are drafting your arbitration clause, keep in mind that what is the nature of dispute which can arise in the transaction that I'm undertaking. If it is simpliciter, let us say a registered lease, and you have that, you can easily incorporate. It's a long-term lease, you have 20 years or 15 years, lease expires. You have a fast track procedure, you can do it. Of course, there can be other issues, but then these are, or it's a simple question of accounts where you have this, where there are balance confirmations and the question of indebtedness is otherwise evident, you can have a fast track procedure. And you can think of, in your field, you can think of that, you have issues where you have experts over there, or you have an issue where the expert finding is, or there are established rates, there are regulators whose findings or whose rates, that's the last word on that. And you can easily incorporate this fast track procedure. So, caution number 1, give time at the time of formation of the contract in framing your arbitration clause or your arbitration agreement in a proper manner. And also ensure that you take adequate precautions to incorporate or avoid. When I say this, that when you are on the other side and you are looking at something where there is a fast track procedure, and if you feel that, no, this is not an issue which can be done with, be cautious of that. Don't sign agreements blindly and then later come and say, well, this is something which has caught us absolutely off guard. So having said that, from the arbitration clause, we come to some mistakes, the common mistakes which men of commerce make. Sorry, I got muted by somebody. In having arbitration clauses. Now, what are the common mistakes? As I said, that concentrate on arbitration clause. 2 or 3 corollaries of that is, you can choose the courts where the dispute pertaining to arbitration will go. This is a very important aspect. And this, in legal parlance, we often call it as a forum selection clause or an exclusive jurisdiction clause. That is, you are a party in Kolkata, you are having a transaction with a party in Delhi or anywhere in India, you can specify in your contract itself that for preliminary applications or wherever you have to go to a court, either let's say pre-arbitration or post-arbitration. When do you go pre-arbitration? That you want urgent or immediate reliefs before the tribunal can take over, or after the award is passed, either you challenge it or somebody else challenges it. You don't have to run around. So you can protect yourself by having a forum or having agreed that, all right, you are entering into a contract with me in Kolkata. So we agree, I'll enter into this contract with you only if I cannot run around all around the country. So we will have all court proceedings challenging anything in the arbitration or in connection with the arbitration only in Kolkata. Now, this sort of takes a backseat so far as international arbitrations are concerned, because when we are discussing commercial arbitration as a whole, we are not only restricting ourselves to domestic arbitration. Of course, my endeavor would be to concentrate more on the domestic and sort of speak as little as possible, but on international aspect. But then over here, it is important to point out that now we have a lot of technicalities as to what we call a venue and what we call a seat of arbitration. To put it simply, where the arbitration is taking place. Now, few years ago, the situs of the arbitration was not much of an issue or not material. But unfortunately, due to judicial pronouncement, which has also found approval from our highest court in our country, the venue is now often regarded as one of the important factors, or the situs of the arbitration becomes an important factor, primarily because of a feature in international arbitration, which we have unknowingly sort of borrowed into domestic arbitration. Now, what is that feature? In international arbitration, in commercial matters, there is this concept of a neutral venue. For instance, a party in China is transacting with a party in USA. So neither the person in USA is comfortable doing an arbitration in China and vice versa. So what they do is, they say that we shall have the arbitration in London, which is not exactly the central point. It's a neutral venue, where neither the American party nor the Chinese party, it is a perception that they will not have any influence in a neutral venue. So that is how the concept of a neutral venue comes in, that for two international, or if one of the parties are of a different country, so it is better to have a venue which is neutral. And a corollary of that is that if an American party is having transaction with Chinese party or vice versa, and when I say American and Chinese, it's not that I'm restricting it to two countries. It can be any, it can be one of the parties can be Indian also. The question is, on what law do you decide? So there again, the concept of the agreement also comes in. And fortunately, so far as the law of contract is concerned, it is 90% the same all across the world, because there are really two sort of, if I can say, there are two places where the law of contract has evolved. One is in American jurisprudence, where they have borrowed from all over. And so far as we are concerned, we are primarily following the British format. And most of the countries which are undertaking commercial transactions nowadays, they fall in either of the two categories. And even other countries who had their own laws relating to contract, that is the Middle East, which earlier had the Islamic law so far as contracts are concerned, they also now, so far as commercial matters are concerned, because they are now international hubs, of course, I'm not talking of the war presently going on, they have sort of streamlined their law and they fall in line with what is commonly followed there. But to come back again, here the law is agreed that, all right, I agree that the law of either, coming back to the same example, USA or China would be applied. Or it is also possible that since we are having a neutral venue, we agree that this contract will be governed by what the law of that venue is. That is, if it is in London, it is British law. If it is in Singapore, it is Singapore law. If it is in India, that's a neutral venue. Now, why I am mentioning this? So in international contract, the venue and that law is indirectly or directly coming in, not only because of the convenience and agreement of the parties, but also because once you have that, you are automatically choosing as to how, and you have that power at the contract stage, how I am going to challenge it. So if you have it at a neutral venue, until and unless you contract otherwise, the challenge has to be in terms of the law where that arbitration is taking place, because the award is passed at that venue. And in 99% contracts, it's so, for instance, if you are having a arbitration in Singapore, you have to challenge it as per the Singaporean laws, until and unless the parties expressly by contract take care of the situation. So, addressing the gathering in a chamber of commerce, why I am going into all this is that you really have the power in your hands to tweak your clause, not only to choose your arbitrator or the personnel or the institution, but you also have the power in your hands to choose, if it's an international contract, in the sense that one of the parties is of another nation, you have the power to choose how and where you want the arbitration to be held, what law is to be applied, and you can also choose how the challenge procedure to that. Now, of course, there are some standard firm contracts where large institutions or multinationals, they say either you take it this way or we don't deal with it. So that is something which you will have to take in your stride. That is really, irrespective of whatever you know of the law or about the law or the nitty-gritties, you are often forced to sort of sign the contract because they are not going to change the terms. Now, that being the position, once you do that, then later on you can't say, well, you see, I was forced to, I did not have any option. If I had to do business, I had to do it their way. So the bargaining power, whether it is equal or unequal after having signed it, we can't look into it. So this is so far as the contract making process is concerned. And this is the most important part where your caution has to be, or your attention has to be focused. Because once dispute arise, then of course you would be consulting your lawyers and you will go into the details of the dispute. But then if you have given enough attention at the contract making stage, much of the problems can be sort of taken into consideration. So we have dealt with broadly what you should keep in mind in drafting a proper arbitration clause, in selecting the place, the situs of where the arbitration would take place, in choosing the courts that you are comfortable with. And then, God forbid, you go into the transaction and a dispute arises. So what do? When the dispute arises and you go into arbitration, as I've already said, you have two procedures. One is the regular procedure and one is a fast track procedure of 29B, where if your nature of transaction permits, you can definitely look into it and look into it in a big way. Because this is the area, and at the cost of repetition, I want to emphasize that I want to emphasize it because this is the proper forum where this 29B can be utilized on a much frequent basis than it is actually done. So the arbitration starts. You either go to the chosen personnel of the who is the arbitrator, or you have a tribunal which is agreed or which is which takes the matter as per your agreement. And in case you are unable to agree, so it is always better to have personnel fixed from the when you are doing the contract itself. And most of the clauses, I find that especially where it's more than one arbitrator, you have one party appointing an arbitrator, the other party appoints his nominee, and then you have the two nominees appointing the third arbitrator, who as per the present law is called the presiding arbitrator. Now, there are virtues and vices of this procedure again, but to be very objective about this is, it is better, according to me, to have a single arbitrator, and it is better to have a choice, to have the personnel zoomed in. On both the parties have the confidence. Invariably, you come across cases where you sort of choose an arbitrator after the dispute arises. Now, technically, there is nothing wrong in that, but then the tendency is, and this is where these are the vices of arbitration, that you tend to choose, and even men of commerce and the sort of tend to choose, you say, all right, I choose a person not because he's well versed in law or he's well versed in the subject that I am saying, that the dispute is being governed. I choose him because he's my man, he is going to toe my line. And this is where the gray area comes in, that you expect your nominee arbitrator to toe your line. Now, in a practical situation, can we say that it does not happen? Answer is in the negative. It happens frequently. Is it an ideal situation? Answer is no. Does it enhance the cause of arbitration? Answer again has to be in the negative. So it is always preferable, and you increase the cost once you have a multi-member arbitral tribunal. If the cost increases manifold. So it is better to restrict yourself to a sole arbitrator as far as possible. It is better to identify the personnel, or at least identify or have some sort of an idea who the personnel is. So if you have a named arbitrator, like the idea is, I go into arbitration only if so-and-so is the arbitrator. Otherwise, no, I go to court. That's a much better option, according to me. If you know if you can zoom in on an arbitrator. But then again, there are uncertainties which can creep in, which it is not possible to foresee, all sorts of uncertainties. So in some sense, an open-ended arbitration clause may make more legal sense than fixing it or zooming in on individuals. And this is where institutional arbitration comes in the sense that, all right, that let us say you have the chambers of commerce having its own arbitration bodies. That, all right, we are both members of a certain chamber of commerce or a certain wing, so we will go by the institutional mechanism which this chamber has. And that is also a procedure which is quite popular. But the flip side of it is that even these institutions, they have what is known as a panel arbitrator. And it is sort of, it goes on a cyclical basis that, so that, you sort of give arbitration to, in a democratic way, to each and every person who's there in the panel, and that's taken care of. So if it is that it is only of experts pertaining to that field, then it's a different matter. But once you sort of open up, then even institutional arbitration has its drawbacks. So then again, at the time of drafting the clause, you keep that in mind, even when you are going for institutional arbitrations. And this is where institutional arbitrations now is coming in a big way in India. It was earlier not that popular, because the institutions itself is restricted, or its members are restricted to a certain field of expertise. It can be a technical engineers institute, it can be chartered accountants institute, it can be, let's say, we are having this session for Bengal Chamber of Commerce, and this is men of commerce or business, and they can sort of zoom in or jot down as to the disputes that they may have. If it is of particular fields only, then you can have various lists of arbitrators depending on the subject matter. It's not that because a certain person is a lawyer or a judge from the High Court or Supreme Court, he is supposed to be an engineering expert, an accounts expert, a technical expert. And this is where things have come in a big way. The virtue has turned to a vice, because we sort of choose our arbitrators and lawyers because of the background of the court from where he or she comes. And that essentially in commercial matters, to a certain sense, if they are well experienced in commercial matters, it's very good. But there are technical matters where you require technical expertise, and that's not the best way to deal with it. So these are the broad parameters which you keep in mind. So we go into arbitration, you engage or you take the best possible help to deal with the situation, and you end up with an award, either in your favor or against you. And it is after the award stage, you face the second hurdle. If you are an award holder, how do you expedite it in a quick manner? And if you have suffered an award, what do you do? So in law, the challenge to an award is limited in the sense that it can, on facts, you cannot have a challenge. You cannot go into the facts again. But then men in law and we have devised ways and methods of sort of opening up the field. And from time to time, we have our own Supreme Court, sort of trying to restrict it and then again trying to open it up. I'm not going into the decisions, how the law has evolved. That's a different topic. But then challenge and the pendency of the challenge is the greatest hurdle that you come across. Because now, of course, a feature has come in that if it is in terms of money, it doesn't operate as an automatic stay. The award doesn't operate as an automatic stay. You have to sort of secure the money. And this is where, if you have your pockets are strong, you can sort of prolong the proceedings and secure it, and God knows when the challenge will be taken up. So this is an issue that, of course, the arbitration may go on smooth. It may be very fast. You have an award in your favor, but you do not know when you will see the fruits of that award. The money may be lying in deposit in court, and for the next 10 years or 15 years, you are deprived of that, the fruits of the award. And that is where the efficacy of the whole procedure is put into question. Of course, there are cases where it has been put into execution on, but then that is more of an exception than the rule. So this is the broad parameters of how and of course, if you are able to overcome the 34th stage, There is an appellate stage thereafter also, right up to Supreme Court so far as domestic law is concerned. So far as international law is concerned, depending upon if it is an institutional arbitration, many institutions have what is called a multi-tier arbitration. You have an appellate body also. So that is as per the rules of your rules of the trade, it goes on. So this is where the arbitration takes you. Now, a quick word on conciliation as well. Prior to this mediation coming in as a compulsory sort of an imposition in commercial matters, the concept of mediation was there in the Arbitration Act itself as conciliation. Now, as I said in the very beginning, that is possible that you give an offer and somebody accepts it and you go to a person and you put that offer and acceptance in writing and he sort of conciliates. And whatever he sort of suggests that, all right, your claim is X, their claim is Y. I think Z will be a good place to arrive at some sort of a midway or some sort of whether it makes commercial sense of it or not. Now, having said that, this concept is always open in mediation, which is imposed in institutions also. You can go there and have this very concept worked out. But my experience says that Indian men of commerce or men and women involved in the Indian context in commercial transactions, either due to the advice of their lawyers or in general, they treat this concept of mediation and conciliation only as a methodology to prolong the issue. That is, if I am confident that my matter is weak, I would prefer to refer it to conciliation and waste some more time and and then come and back out, because the advantage is that, till such time I enter into some sort of a settlement, it's not binding. So you buy more time. So conciliation and mediation, and even when it has been compulsorily imposed, you will find that most of these compulsory mediations, even in suits and all, because now before you can go to court in commercial matters, you have to explore the possibility of mediation. So 99% matters, you will find that the mediation is a non-starter. It doesn't even begin, because 99% matters, two commercial sides very well know what their respective cases are and whether at all a midpoint can be arrived at. So even the person whose case is weak, he is aware that I go to conciliation, all right, this is the maximum I can go to reach a midpoint, but then again I'll be that. So it's better I go to court. Why? Because I get more time, I get more breathing time. This is how the entire concept of mediation is being abused, and in that sense the concept of conciliation is also being abused. That, all right, if I spend 6 months or more than 6 months in a conciliation, I buy that time, and after that we say, well, conciliation has failed, so let's go for arbitration or let's go for suit or whatever. So this is something where people involved in commerce have to devolve or have to give a second thought as to how the process of mediation or conciliation can be sort of regulated to make it more meaningful. And there, if you have your own conciliators or mediators, it is, when I say your own, I mean, let us say you are a chamber of commerce, you have your own conciliators and mediators, and you can incorporate an element of conciliation in the agreement itself, having a chosen conciliator or a mediator. That is also possible. And this is something which is somewhat unexplored so far as we are concerned. You still have the freedom, and if the men and women involved in conciliation and mediation are experts or are men and women of repute, then you never know, this field of law can have it's the benefits that it envisaged can be taken. You can have the benefits that the law originally envisaged. So this is the brief aspect of conciliation. Now, before I take questions, because it's almost an hour now, so let us now try to sort of assimilate what are the broad takeaways or broad parameters of this session. I would not like to call it a lecture, though in a virtual format it has almost turned out to be a lecture. So the broad parameters are these. Have your full attention when you are entering into the contract. And design your arbitration clause and your dispute resolution procedure by taking whatever help you can at the very beginning. And not go to the best of the lawyers after the dispute has arisen. That's the first takeaway. The second takeaway is don't copy paste contracts, because big concerns have done it in that. You end up in disaster. Have contracts tailor-made for your purpose. Of course, you can copy paste contracts. You can have cyclostyle agreements if it is the transaction is of the same nature. That's of course permissible. But when you are having the first impression, when you are creating a contract in respect of a transaction which you have not done before, have tailor-made dispute resolution contracts. Third takeaway, while having this, be careful as to where you have to have this adjudicatory process implemented, which is the place, because that really has a say on your commerce, in the sense that your cost of litigation, doing it from the place where you are doing business makes more sense than going outside or leaving your place and going somewhere else. So venue and all these comes in. And of course, for international purpose, you have this neutral venue where the choices are limited. But then again, so far as international procedure is concerned, you have these reputed institutions where you have a fast track procedure. But of course, the costs are something which often renders such remedy elusive. And lastly, when you have an award, you have only two options. If you have suffered an award, you follow the challenge process. And if it is monetary or otherwise to secure a stay, you have to be prepared to fork out the money. Otherwise, you don't get it outright. And if you are an award holder, then you have to have strong pockets to be long enough in the game and beat them at their own. That so long the 34 goes on, you have to be patient enough to really see the fruits of the award, because they, by securing the awarded sum or putting in that they can easily secure a stay. So these are the broad parameters. I hope I have covered. I don't know how useful it was to all of you, but this is the broad parameter that you can have. And now, if you have any questions, I would be happy to answer them.
Thank you, sir. Yes, there are many questions which have come up in the chat box. I would request Mr. Obhimanyu Das, who is part of our Bengal Chambers legal fraternity and has been a regular participant of such sessions. He has few questions. He has joined us from Shiliguri. Obhimanyu, if you can please put forward your questions.
My question is that, first of all, can we go before conciliation, before going for any type of arbitration agreement?
Yes, you can. You see, there are many arbitration clauses where you have a condition precedent to arbitration. Like you will find clauses where they say that you will have to first go to the chairman of the company and then he'll try to conciliate. And if he doesn't arrive at within this date, then you invoke arbitration. So you have conditional arbitration clauses. Just as you have conditional arbitration clauses, you can have a conciliation mandatory, or if the parties agreed, prior to invoking of arbitration. I can give you a ready example. There are some statutes which incorporate this. For instance, there is an act called what we say commonly as MSME Act, Micro, Small, Medium Enterprises Act. Over there, you have this statutory conciliation and arbitration, section 18, I believe. So if you are a sort of a small or a micro unit, a medium unit is not there, a small or a micro unit, you can, by way of statute, you can invoke. First step is conciliation, and the second step is, if the conciliation fails, then it is arbitration, and the same institution does it. So you have statutory examples, and I see no reason to answer your question why you cannot incorporate it in a contract. But then you see the conciliator or the person to whom you go to conciliate have to be, or have to have that stature to sort of make you arrive at that midway process or whatever.
Thank you, sir.
Thank you, sir. Sir, we have our next question from Mr. Vineet Agarwal. Is Mr. Vineet Agarwal still there? You would like to ask straight away, or do I ask on your behalf? So his question was, the outcome of arbitral proceedings are regularly challenged by the aggrieved party before courts, which inevitably further delays the finality of the dispute. Any mechanism suggested to avoid such reference of arbitral outcome to courts?
I take it that the question is whether you can avoid the challenge process.
Yes, yes.
Right. Well, under the given circumstances, the answer is no. Like, the law of the land does not permit, you cannot avoid the law, or you cannot bypass the law, or you cannot have an agreement which is contrary to law. So if it is an arbitral award, the challenge is there, and the law permits that challenge. You cannot make an agreement and say that, well, we agree that it will not be, there will be no challenge. But then, yes, you can have multi-tier arbitration in the sense that you can, but then again, even if it's a multi-tier arbitration, even if you go to the top tier, that also is subject to the challenge. So there is no procedure. And this is in a sense good, because you see, it is wrong to focus only on commercial expedition. Please also bear in mind that you have to strike a balance, that you can't have the arbitral tribunal having the last word without any sort of check. So that is something which also has to be kept in mind. Of course, that check has now been stretched and prolonged into an agony, but then that is the vagaries of law. Just because a system is being abused doesn't mean that it should not exist. But to answer your question in a straightforward manner, there is no way to bypass the challenge process.
Thank you, sir. Next question which we have is from Ms. Kea Kundu. Ms. Kea Kundu, would you like to place it by yourself? So Ms. Kea Kundu's question was, what will be the key rules to follow by any budding advocate to take interest and get indulged themselves in arbitration as their future profession?
Okay, I take it that the question is budding lawyers wanting to specialize in arbitration, right?
Yes, sir.
Now, you see, so far as law is concerned, you can't be a specialist either by having degrees or joining one particular course or another. So the easiest and simple way of specialization is having experience. So if you want to be an expert in arbitration, do as far as increase the numbers of arbitration where you can participate, either as juniors or as interns or as in any form whatsoever. Even, it's a great idea to join, arbitrations process for budding lawyers. You spend 6 months or 1 year in these various institutional arbitrations that take place, either as secretarial assistants or offering there are now, most of the arbitrators have their own sort of law clerks, and it's a good experience you gather by assisting these arbitrators, and of course, if you are fortunate to, join chambers of councils who are into regular arbitration. Experience and only experience will make you an expert, and not any degree, or not, there is no straight line formula in that. And of course, your hard work, that's a general field. But experience and only experience. How you acquire that experience and where? It can be a very small experience. It can be a very big experience, in the sense it's not necessary you get the greatest of experience in large arbitration. Even small, minuscule arbitrations, it can deal with a field of law or a facet of law which is very interesting and which has a profound impact on your development as a professional in the initial stage. So for budding lawyers or budding practitioners who want to take up arbitration, do as much as possible, or experience arbitration as far as possible, either by being there physically or virtually. And when I say by being there, I mean by, sort of being involved in that arbitration 100%.
So the next question is from Mr. Subhash. He says that if the seller and buyer are in different state, what should be the venue of arbitration? And further, what should be the number of arbitration?
Okay, so let me dissect the question in two, because it's two questions rolled up in one. To answer the second part first, number of arbitrators, you are free to agree. That is, there is no hard and fast rule that you have to agree to 3 or 1. You can agree to anybody, to any number. It's preferable to have the law supports, having uneven number, so that, you don't have a tie. But cost effective, try to zoom in on a sole arbitrator, because that is how the litigation costs are kept to a minimum. But then if you are unable to zoom in on that, then you have no other option but to have the most popular method, that, all right, the seller appoints one nominee, the buyer appoints one, and both the nominees appoint what is called the third arbitrator or the presiding arbitrator. That is how you decided that. But then it is always cost effective to have one single person as the arbitrator. Try to zero in on a person on whom both of you have faith, either because of his impeccable repute or because of, some other consideration, whatever he is a man in your field of expertise or in your trade. This is the first part. The second part, the answer to the second part of the query is, where do you have that? Where do you agree? Now here, just bear in mind that, let us say you are from Calcutta and you are transacting with a person from Bombay. Both of you can agree to any court that only courts in Calcutta will have jurisdiction, or you can agree that only courts in Bombay will have jurisdiction. Now, you cannot agree that is why I said that the neutral venue is a misnomer here. You cannot agree that courts in Delhi will only have jurisdiction because Delhi is neutral. I have to go from here to Delhi, and that. Of course, now the law is somewhat, it is still getting developed, but the classical rule is that a court which does not otherwise have jurisdiction, the parties cannot agree and confer. So to answer it simply, you can agree either to Kolkata, any court in Kolkata, or courts in Kolkata will have jurisdiction, or courts in Bombay. So if you are having a buyer-seller contract and you are in a position to insist that, look, I am selling all over the country, I insist that if there is a dispute, you come and approach the courts where I am situated. But you can't have a neutral place court. All right, you don't come. And in case you try to do so, or you agree to do so, let's say, then you have to show that what we call in law, what is the cause of action. That, all right, I agree, you are in Bombay, I am in Kolkata, all right. Please come to Delhi. Let us finalize the contract in Delhi. And because the contract is being finalized and concluded in a neutral venue, courts in Delhi will have jurisdiction. So in law, you must have something arising at that place to confer the court's jurisdiction. Otherwise, it's very clear. It can be either where you are there or either where the buyer is there.
Noted, sir. There is another question by Partho Banerjee. Mr. Banerjee, would you like to place your question?
Yes.
Please do.
Sir, we have found, please tell us whether the MSME Council can decide contract or adjudicate contracts relating to purely work contract.
We request Mr. Vikas Chaudhury to mute. Thank you.
Yes.
Yes.
Well, if you ask my view, this entire law relating to works contract and MSME, there is nothing in the MSME Act which excludes works contract. There is nothing in that. Now, this entire issue has cropped up because of Section 11 of the MSME Act. You will find that under the MSME Act, there are certain concessions which are given to MSMEs for government procurements. That is, if the government is procuring rupees 100 worth of goods, then 20% or 10% worth of goods, which are of minuscule importance, like let us say pins, papers, stationery items and all that, not relating to defense or specialized items, you have to compulsorily procure it from MSME. It is in this context, there are 3 or 4 stray judgments where this came up in issue, and you had a judgment saying that, interpreting Section 11, saying that you have to be both a manufacturer and supplier, seller of these items to qualify to get the benefits of Section 11. And in that context, the stray line was there. If it is not, and these are works contract, where an element of service is also involved, it is not within the purview of MSME. And unfortunately, that has been adopted by some other courts without going into the issue, completely forgetting that it was a Section 11 case, which has nothing to do with. Now, nowhere in the statute or MSME Act, you will find any restriction that works contract are excluded. So it is only those stray judgments. Fortunately, we have Calcutta High Court judgment, and now some of the other high courts have sort of looked into the matter. But now I believe the matter is pending in Supreme Court, and we should have. But given my view, there is nothing in MSME Act to exclude a works contract, because it's a beneficial legislation. You are a micro industry, you are a small industry, you get the benefit of that act.
Thank you, sir. Sir, there was another question from Ovimonyu, that the role of AI. In the modern era of technical advancement, can AI be an arbitrator?
Well, it really depends on how the AI progresses, or what would be the advancement so far as AI technology is concerned. Given that it has still now, the progress that AI has made, it is phenomenal, I tell you, that in the sense that, there are people who are using AI, and especially the juniors, that you feed in data, it churns out excellent list of dates. You feed in, you ask them to ask AI to prepare a note. So far as any proposition is concerned, it will, sort of analyze data from the net, and it will prepare notes which are very impressive. Of course, the citations and references are invariably wrong, but now you have specialized legal softwares where you don't have that problem also. So I can't rule it out, in the sense that, you already have now AI adjudicating. In the sense, I'll put it in minimum words as possible, lest I be guilty of contempt. I can't say that. You see now, if you read judgments of even higher courts, and I put it over there, you will find judgments have reference to various cases which perhaps may not have anything to do with the matter. But then these cases have come in because of the inputs of what we call the law clerks. And most of the law clerks today who assist the judges, they are well versed in AI. And you can make out when you read judgments that which part of it is, it doesn't fit with the rest of the body of the judgment. And you will find that now earlier it used to be rare. In fact, I believe one of the honorable judges perhaps lost his elevation to the Supreme Court because of, AI quoting from some article and that getting in a judgment and all that. So these are there. But then, yes, to answer your question, I won't be surprised that if in future it does, because you see, logically, what do we do? Or what do adjudicators do? It sort of assimilates the law, puts in the fact, and then says that where you can apply it. Now, if you can program AI to that level, but then AI will first take up the jobs of the lawyers before it does that of the judges. So the threat is more immediate to the lawyers than to the judges.
Sir, we have another question from Jay Narayan Ghosh. Mr. Ghosh wanted to ask you some question. He is an FCS and head legal of a company. Is Mr. Ghosh, I can see Mr. Jay Narayan Ghosh. Can you unmute yourself and ask the question? Mr. Ghosh, are we audible to you? I think let us take his question later on. Mr. Dhruvo Basu, he has said that can we bind other side to go definitely under section 29B as discussed by you? So would you like to answer that?
Yes, very much. I mean, in fact, I can just read section 29B for your convenience. I mean, 29B is as good as an arbitration agreement as any other. So if you are aware and if you are confident that the nature of the dispute can be, it can come. It's 29B is itself, the heading is fast track procedure. So it's saying, notwithstanding anything contained in the Act, parties to an arbitration agreement may at any stage, either before or at the time of appointment of arbitral tribunal, agree in writing to have the dispute resolved by the fast track procedure. So in fact, you see 29B, you can even agree after the dispute has arisen. But then you see, after the dispute has arisen, it is difficult to make a party agree, because two commercial parties, they are very well aware of their own strengths and weaknesses. The weaker party invariably will not want a fast adjudication. So commercial prudence demands that you get the agreement done at the first instance and not after the dispute arises. But to answer your question, yes, you can. And that is how an arbitration takes place. Without agreement, fast track or slow track, you don't have, without agreement, there is no arbitration.
So Mr. Joy Jyoti Hor has asked, remedy
Sir, may I interrupt? Sir, one more thing I want to ask. Should I put this point in our agreement or in the proceeding?
No, the arbitration agreement provides. There are cases of arbitration agreements providing that parties agree to adopt the fast track procedure as envisaged in section 29B. Or you can have similar clauses, you can have your own clauses. But it is very important, whenever you are having a fast track procedure, be confident and careful of the personnel of the arbitrator. I mean, fast track procedures are very good, but then if you see it falls in the wrong hands, it can be abused to point infinity. So that is why, and it is only applicable in a sole arbitrator situation, because moment you have three arbitrators, the law presumes that your disputes are so complex in nature that it can't be fast track. That is why you will find 29B, it is sort of, the provision is for a sole arbitrator.
Thank you so much. Thank you so much, sir. Actually, the expenses also matters for my client. That's right. Great. Thank you.
Expenses, that is why you have the fast track procedure.
Sir, another question from Advocate Boshundhara Dhor. She's saying that, do you think India will move to statutory recognition of emergency arbitrator after Amazon versus Future? What gaps still remain for practical enforceability?
No, emergency arbitration in law, it is not yet a very mature concept. So there is nothing called an emergency arbitration. But then at the end of the day, it is an agreement between two parties. So we need not be unduly worried about that. Of course, I am not, to be very candid, if there is any special ruling so far as Amazon is concerned, I am not very well versed with that Amazon ruling. So I'll be very candid. If there is any special or if there is any suggestion, then I'll have to make myself update. I have to update myself. Update on that. But so there is nothing so far as emergency arbitration is concerned, or it's end of the day, it's a contractual issue. If you can do it, you do it in that way.
Thank you so much, sir. I think this shows that this entire session was extremely engaging, and we really practically had 25 minutes of Q&A. So that was really, really very encouraging, and this shows how important this subject is. We have Prashanto Dotto sir amongst us. Paritosh sir, I think, is also there amongst us. Prashanto sir, do you want to say something before we give a formal vote of thanks to Sabyasachi sir?
I can only say that it was a wonderful session, and it educated every one of us. Even almost 50 years of practice, I have also learned. So thank you so much.
No, I am grateful for this opportunity to interact with the Chamber of Commerce, and thank you to Prashantoda, to Mr. Mitro, to Mr. Sinha, and to all of you for giving me this opportunity. And I just hope that I have tried to keep it as far as possible in simple terms, but then when lawyers speak, legal terms automatically come in. And let's hope that the session would benefit the members.
Absolutely, sir. Absolutely. Sir, on behalf of the Bengal Chamber of Commerce and Industry and all our supporters of this initiative, Victor Moses and Company, Sinha and Company, Advocates Sandersons and Morgan, we really thank you for taking out time from your busy schedule and agreeing to address our members and the fraternity as a whole. So thank you very much on behalf of the chamber, on behalf of my co-chairmen and chairman. And we also thank all the participants who have joined on a Friday evening with us. With this, we again look forward to another enchanting session very soon. And thank you so much, sir, once again on behalf of the chamber. With
My
this,
pleasure.
we would like to
Thank you once
say
again.
good night to you all.
Thanks, everyone.
Thank you. Thank you.
মিটিংটা কাম জন্য